But first, we're going to check in on a lawsuit from small Grants Pass, Oregon that could be headed to the highest court in the nation, potentially reshaping homeless policy for years to come. That is our big story tonight. First things first, the U.S. Supreme Court has not said it would even take this case from Grants Pass. So let's be clear on that. But a lot of legal experts seem to think, yeah, they probably will. The case involves 5 laws that Grants Pass enacted to keep homeless folks from camping there. The federal Ninth Circuit Court of Appeals said, no, you can't enforce those. The Ninth Circuit judges had already ruled in another case called Martin v. Boise that you can't punish homeless folks for camping in your city unless you have a shelter bed ready and available for them, and then they refuse to take it. Otherwise, the court ruled, it violates the 8th Amendment regarding cruel and unusual punishment. So this Grants Pass case, if it's taken up by the Supreme Court, could overturn the Boise ruling, which would be huge for cities trying to control homelessness. The Ninth Circuit, by the way, if you don't know, it's massive. It covers 9 western states and about 67 million people. So when a case this big is filed, other folks who have a dog in the fight can sort of join in with the main group filing the case. Here's comments from a lawyer representing 2 groups that have done that very thing. First, Timothy Sadafer. He's a lawyer with the conservative Goldwater Institute in Arizona.
We've asked the Supreme Court to take up the Grants Pass case and in reviewing the case to overturn both the Ninth Circuit's decision in that case and the Ninth Circuit's decision in the Martin case, because these decisions are so poorly reasoned that at best they've been creating a tremendous amount of confusion for city officials trying to deal with the homelessness problems in their localities. And at worst, have given an excuse to city officials who don't want to do their jobs to not do it. Because what the Ninth Circuit said is that it's unconstitutional to arrest somebody for sleeping on the sidewalk if there aren't sufficient shelter beds to accommodate those people. And notably, the Ninth Circuit excludes from the count shelter beds at church-run facilities. So that, of course, churches are the #1 source of homeless aid. So to rule them out entirely then is to kind of load the dice in that calculation.
All right, so that's one side. On the other side, Eric Tars, also a lawyer for the National Homeless Law Center. His group wants Martin v. Boise to stay in place, which would mean either the Supreme Court doesn't take up Grants Pass case or rules against the city.
Quite frankly, the proposition that the Martin versus Boise and Grants Pass cases stand for is really quite a low bar under the 8th Amendment. All it says is that communities can't punish people experiencing homelessness for undertaking basic survival activities, sleeping, sheltering themselves from the elements, if they don't offer them an adequate alternative place to do those things. So the only reason that you would want to overturn that is if you want to be able to punish people for those activities without even bothering to have to offer an alternative. These amicus briefs that are being submitted, they complain that Martin versus Boise binds the hands of communities, prevents them from being able to solve homelessness. If that was true, then in the decades before Martin versus Boise became law in the Ninth Circuit, then we would have solved homelessness. But criminalization didn't solve homelessness back then, and it's not going to solve it now.
Martin v. Boise was decided about 5 years ago in 2018. So there you go. A couple of the big picture arguments for and against overturning that case law that keeps cities from enforcing camping bans against homeless folks. Now, back to our Supreme Court case and the filings by so many other groups wanting to weigh in on these arguments. Mostly, they send something to the court called an amicus curiae, which in Latin literally means friend of the court. The filing is a written argument called a brief, which tries to influence the court's decision. And that is happening big time right now. Let's take a look. Everything is electronically filed, which is pretty cool. It makes it easy to find online. This is the case from Grants Pass. It's called City of Grants Pass v. Gloria Johnson. Johnson is a woman who lived out of her car at parks around the city and is one of the original 3 people for which lawyers filed the lawsuit that started this whole thing. Earlier rulings in the case broadened it out to include everyone who is homeless in the Grants Pass area. Now, as we scroll down, you'll see there's a lot of these amicus filings. Some say amici because there is more than one group represented in the filing. By the way, that's your Latin lesson for the day, no extra charge. Amicus is friend, amici is friends. Okay? I counted 24 different briefs filed so far. They come from Oregon and Washington and California and Arizona and lots of other states. They span the spectrum of liberal to conservative politics, from, for example, the conservatives in the Arizona legislature to the progressive governor of California, Gavin Newsom. Now, I hope to interview Governor Newsom for this story, but as people said, he's too busy, which really means you're too small for us to bother with. That's okay. They sent us a statement and said, which I find fascinating. It reads in part, "Well, I agree with the basic principle that a city shouldn't criminalize homeless individuals for sleeping outside when they have nowhere else to go within that city's boundaries. Courts continue to reach well beyond that narrow limit to block any number of reasonable efforts to protect homeless individuals and the broader public from the harms of uncontrolled encampments." And he goes on, "It's time for the courts to stop these confusing, impractical, and costly rulings that only serve to worsen this humanitarian crisis." He also points out his state is spending billions of dollars to address housing and homelessness, but that the courts have tied California's hands, like that lawyer said, when it comes to dealing with the problems of homelessness. One of the interesting things about this case is that it has attracted attention from all over the political spectrum. Sandifer from the Goldwater Institute says, well, that just shows how widespread this problem is. Spectrum.
Yes, and understandably so, because the Ninth Circuit's ruling is so irrational that it doesn't make sense to anybody but the most rigidly ideological fringe of the left. And so we're glad to see that cool heads are prevailing on both left and right and asking the court to take up this case. And I don't see how they could possibly not take up this case. It's such a big deal. It has caused so much chaos throughout the West. And as you said, left and right both are urging the court to take action. And only the Supreme Court can fix this problem, because the Ninth Circuit's ruling stays in place unless the Supreme Court acts.
Now, I've read through some, but not all of the filings. One fact that did catch my eye comes from the League of Oregon Cities, and specifically the city of Portland. It states that between May of 2022 and July of 2023, Portland officials made 3,399 offers of shelter beds to homeless people. 2,560 said no. Now, that's a big number. That's 75%. 75% of the time shelter was offered, the response was no. So I asked Eric Tars with the National Homeless Law Center about that. Doesn't it show that most people don't want shelter? Shouldn't that impact the federal case, which is all about requiring cities to have shelter for people who are homeless?
Well, the city should be looking at what it's actually offering. There's a lot of evidence coming out of the pandemic that when people were offered dignified, safe, private spaces, the hotel rooms and motel rooms, that they could stay in for a longer period of time and offer them a safe place to be, that they took those up at 90% plus rates. So it's not that people are shelter resistant, it's that the shelters are people resistant. And so rather, if the only way that you can get somebody to accept an offer of shelter is by forcing them into it under the threat of arrest, then it says a lot more about what's being offered than it does about the person rejecting it. There's so many legitimate reasons why a person might not want to be able to go into shelter.
And he pointed out that some shelters have curfews that could make it hard for homeless folks who work, for example. So there you have it. Some of the many, many arguments that are being made on both sides of this issue. I'm sure there'll be even more as time goes on. And we'll be watching closely to see if the Supreme Court takes up the issue. A decision is expected by January. In the meantime, we, of course, want to hear from you. What do you think about this case? Should the nation's high court take a look at it, or should policies stay the way they are now? You know what to do. Whether you're watching live or later, we do want to hear from you. The email is thestory@kgw.com, or call and leave a voicemail, 503-226-5090. I look forward to hearing from you.